Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is A Power Grab Too Far? The European Commission extends its merger control reach. Article 22 permits European Commission member states to request that the EC examine a merger that does not otherwise meet the merger control thresholds. In 2020, the EC announced its plans to reinvigorate the use of Article 22, which has previously been used only in rare instances, and in 2021, the EC took up its first such referral to review the Illumina GRAIL transaction. In this episode of Our Curious Amalgam, we explore the origins and use of Article 22, as well as its limitations. Joining me today is my co-host, Matthew Hall. Hi, Matthew.
Hi, Christina. It's good to be back.
Welcome back. So what are we talking about today?
As you said, we're going to discuss this amazing case from the EU, which is probably the most high-profile example of the increasing reach of merger control review worldwide and the difficulties that can be encountered when going through the process. We're going to look at what it means in practice and also what it's symptomatic of.
And who's our guest today?
Well, we're very pleased to welcome Salomé Cisnal de Ugarte. She's a partner in the Brussels office of law firm King Spalding. And as part of the firm's global antitrust practice, she provides strategic and legal advice to companies and investors in complex competition matters, representing clients before the European Commission in Brussels, as well as national competition and the authorities and the European courts. Hello, Salomé.
Hi, Matthew. Hi, Christina. I'm delighted to be here. Thank you for having me.
Well, thank you for joining. As we mentioned in the introduction, the issue we're going to discuss is the famous Article 22 of the EU merger regulation, and in particular, the acquisition by Illumina of GRAIL. Just to give a bit of introduction to that transaction, which is making a lot of waves here in the EU or in the UK as well, and also elsewhere. Illumina is a US-based global genomics company and a leading supplier of next-generation sequencing or NGS systems for genetic and genomic analysis. GRAIL is also a US-based company, so the target in this acquisition, which develops cancer detection tests relying on next-generation sequencing systems. It is, or was, because the transaction is now closed, a customer of Illumina. And importantly, these NGS systems of Illumina's are a crucial input for the development and commercialization of the tests produced by GRAIL. It's quite interesting to note that GRAIL was actually founded by the purchaser Illumina in 2016, spun off later that year with Illumina retaining a small stake. So the transaction was actually Illumina rebuying the rest of GRAIL for what is an extraordinarily large figure for a company of that size, US dollars 7.1 billion. Also, very importantly, GRAIL was really a startup. It had initiated a limited commercialization of its flagship product only in the US in 2021, earlier this year. It had no sales in the EU or indeed anywhere outside the US. So it was therefore not notified for merger control approval at the EU or the EU member state level, since it had no sales or presence at all in the EU. So that's the background to this fairly remarkable story. So Salomé, we've heard reference to Article 22 of the EU merger regulation. First, can you just take us through what was the history of that? Was it in the EU merger regulation from the very beginning?
Well, Article 22 is indeed not new. It was originally called the Dutch Clause, and it has been in the merger regulation since the very beginning in 1989. It has, however, undergone some changes since then. So in 2004, the recast EU merger regulation greatly elaborated on the process, including adding for the possibility that the European Commission invites a member state to make a referral request. Following that, additional clarifications on the scope and process were provided by the Commission notice on case referrals in 2005. Now, despite having been there since the early days, it is also true that this provision has been rarely used. I believe there are less than 50 cases since 1989. And there are less cases where the member states did not receive a notification. This was probably due to the fact that until literally this year, the European Commission's position has been to actively discourage referrals by member states where the national jurisdictional thresholds had not been met.
So Salomé, before this change from March 21, what was the Dutch clause or Article 22 there for? Why was it in the regulation at all?
Well, originally this provision was included in the merger regulation to allow member states that did not have a national merger control regime to ask the Commission to examine transactions that, in their view, merited antitrust scrutiny. So this was the case, for instance, of the Netherlands, which at the time did not have national merger control rules and hence lacked the appropriate toolbox, the legal instrument, to assess transactions that could negatively affect competition on the market. Now, today, all member states have adopted their own merger control laws, with the exception of Luxembourg. So, from a historical perspective, Article 22 is arguably redundant for its original purpose. So today, with practically all member states having a national merger control regime, Article 22 allows for the reattribution of cases from member states to the European Commission if certain conditions are met. So these are cases that, technically speaking, lack an EU dimension because they do not meet the thresholds, the turnover thresholds under Article 1, and are hence considered to be too small for an EU review, but at the same time might or might not satisfy the merger control thresholds under national rules.
That's a crucial point that I think we should understand here. Certainly in my experience, where the transaction's too small for the EU and also too small for national thresholds, basically up to the new guidance, it's been pretty certain that you're not going to be looked at. And that's what's changed, hasn't it here? We're now not certain. In that scenario, you could still be looked at.
Yeah, absolutely right. That's exactly the situation we're in. Before the March 26 guidance, these were transactions that were not really looked at, and certainly not by the European Commission. As I said, the European Commission until now was explicitly discouraging this kind of referrals. It considered that cases where the national jurisdictional thresholds were not met were generally, and I quote, not likely to have a significant impact on the internal market. The situation has now completely changed, and the European Commission is actually encouraging the referral of transactions that do not trigger merger control filings at EU or at national level, as was the Illumina GRAIL case. And this, even if the deal has closed. On top of it, the new guidance was applicable with immediate effect, without any kind of transition period or notice other than this general remark during the IBA conference that Christina referred to earlier.
And what happened I think, as Christina says, it was kind of pre-announced in 2020 and then formally, if you like, introduced in 21. What types of transactions are they now focusing on and saying that they may encourage these requests even where they're too small for member states to review? What are they now trying to focus on?
Well, this is indeed the key question, right? What kind of transactions are going to face this kind of referral situation? The guidance elaborates on the legal test under Article 22 and also looks at the categories of cases that the Commission is considers to be appropriate to be referred to. So in terms of the legal test, we know that there are two conditions that need to be met for a case to be considered a candidate for referral. First, the transaction needs to affect trade between member states. And second, and this is cumulative, it needs to threaten to significantly affect competition within the territory of the member state or member states making the request. Now, as to the second condition, the guidance provides what they call relevant considerations to determine the kind of cases that would be falling thereunder. So the guidance speaks about transactions that could lead to the creation or strengthening of a dominant position, transactions that could eliminate an important competitive force, like in the kind of a killer acquisition situation, transactions that could lead to the reduction of competitors' ability or incentive to compete, and finally also those situations that could constitute an incentive to leverage a strong market position from one market to another by way, and they specifically mention tying or bundling or other exclusionary practices. Now, the guidance further states that referrals may also be appropriate in cases where the turnover of the target does not reflect its actual or future competitive potential. So it provides a couple of illustrative examples of when this could be the case. So, for instance, when the target is a startup or a recent entrant with significant competitive potential but is not yet generating significant revenues, or when the target is an important innovator or an actual or potential competitive force, or when the target has access to important assets from a competition perspective, such as raw materials, data, infrastructure, or intellectual property rights. Now, a final element to be taken into account in the assessment is the value of the transaction. So the guidance specifically mentions the value of the transaction when it is particularly high, i.e. significant multiples of the enterprise value, to be an important element of consideration.
The guidance refers specifically to tech and pharma, although of course it's not restricted only to those sectors. Then, as you say, but it then also talks about a very wide range of potential transactions. Is this really do you think this is going to go wider than a very narrow type of transaction, or is it giving rise to a lot of uncertainty more generally in transactions that are being done in the EU?
Yeah, absolutely. I do think that this is giving rise to significant questions and a lot of legal uncertainty in terms of the scope, but also in terms of process and timing. Let me give you some examples. So, as we said, the categories of cases is not really clear-cut. The criteria are quite broad. And also with regard to the industries, it is true that the guidance refers to the digital economy and pharma specifically. So big tech and big pharma are definitely at risk here. But paragraph 20 also confirms that transactions in literally any sector can be affected by a referral. Also, in terms of the standard of proof, this is a big question mark for me too. So the guidance requires member states to demonstrate that there is a real risk that the transaction can have a significant adverse impact on competition and therefore deserves close scrutiny. Now, it also says that this analysis, which is preliminary in nature, may be based on prima facie evidence, to be seen what exactly this will mean in practice, right? And finally, timing issues. Member states have 15 working days since the transaction was made known to them to make a referral. Now, this is understood as the member state having significant information to make a preliminary assessment. But again here, when? When will this be the case? This could potentially be after the transaction has been implemented. So closed transactions might also be the subject of the referral. And just think about the Illumina GRAIL case.
Let's take that case. We mentioned it. It's an extraordinary case, really, giving rise to a number of firsts in EU merger control. What do you think about it? We have the first time a company has actually implemented or closed a transaction during a commission merger investigation. We've got the first time the commission is trying to impose measures on a transaction, interim measures. What do you think are the lessons from that transaction?
Yeah, this is an amazing case on so many accounts, as you rightly say. Now, in terms of lessons, I guess it's early to say, as the commission decision to accept the referral is pending an appeal before the General Court. In the meantime, my personal takeaway is that even cases that do not require a filing at EU or national level will still need an upfront, more substantial competition assessment. Particular red flags are specific sectors like tech and pharma, cases where innovation plays an important role as a parameter of competition, cases where the access to valuable assets like data or IP rights will be essential, and those cases which include a very high value of the transaction.
Particularly interesting in that, for me at least, I mean, and maybe this is an easy way for people to determine if there's a real risk. But as I mentioned in the introduction, Illumina is spending over $7 billion on a company which has basically zero turnover. That issue is referred to in the guidance. Do you think that it's really only cases where huge sums are being spent for some reason on a target that we should be concerned? Or do you think it goes beyond just saying, look, we're spending a huge sum for a company. There must be some reason that sum is being spent. Do you think that's really the issue we should be worried about?
Well, I do think that it goes beyond just having a huge sum. Value will be an important element to consider, especially when it is particularly high compared to the current turnover of the target, as the guidance says. But it is one element in the equation.
Do you think on the other way around that, you know, they're not, these cases are not really going to be referred unless up from the or referred to the commission unless there's some indication in what's being paid that indicates that there must be some good reason for this acquisition to take place? Because otherwise, why would you spend, you know, do we need to see a huge deal value compared with turnover before we're going to get these types of references?
Well, I guess you're probably right, and this is what will happen in practice. Now, at the same time, I believe that we cannot read the guidance as introducing a value-based threshold through the back door. This would require a legislative change.
we should be potentially worried about the Commission wanting to look at even small transactions where there wasn't a lot of money spent. So we need to think about it more widely. What do you think, just stepping back from this, just stepping back a bit, what do you think about the Commission grabbing this, or really doing this incredible expansion of its jurisdiction and this incredible U-turn? Do you think that was really necessary to catch these? You referred to killer acquisitions. There are also other types of acquisitions that have been. We also use the phrase, reverse killer acquisitions and zombie acquisitions. These are all acquisitions which might be caught as well. Do you think that the Commission really needed to do that? Really a problem that was there to be caught?
Well, the Commission refers to it as necessary because of a perceived enforcement gap. And it is true that certain transactions, like acquisitions by incumbents of nascent competitors in the tech and pharma sectors, that could play a significant competitive role in the future, do not generate any revenues at the moment of the transaction, and hence escape all sort of merger reviews because the turnover-based thresholds are not met. And it is also true that there has been a lot of debate for years in the EU about whether the European Commission might be missing useful reviews of these kind of transactions. Now, having said that, the guidance is a complete U-turn, and it has been introduced without any public consultation and without any transition period. The European Commission refers to it as a new policy or as a revised approach. To me, it goes beyond that.
So Salomé, Matthew mentioned that this is sort of a first for the EC in that the parties closed the transaction amidst an open EC investigation, and usually parties risk significant liability to do that. Was the EC successful in trying to use Article 22? Is that a accurate way to get jurisdiction? I guess that's, is there any challenge to whether this is legal or not? In terms of EC having jurisdiction over the case?
Well, I guess this is indeed the fundamental question. On its face, you could argue that the European Commission has applied the strict wording of Article 22. It has invited a member state, in this particular case France, to submit a request for referral, which was then joined by a number of other member states. And it has accepted the request for referral on the basis that the substantive legal test that we discussed earlier was met. Now, whether it went too far in grabbing jurisdiction on a case like the Illumina GRAIL one, and whether it acted within its margin of discretion, well, this is something that will depend on what the European courts will say in the current appeal proceedings. So, as you know, the parties have challenged not just the decision to accept the referral from France, but also the decision to accept the other member states join the French referral, and also the request for referral itself. So clearly, this case will shed some light on many of the issues and questions that we have been discussing today.
As you say, Salomé, Illumina has appealed that, and so the court will ultimately decide whether the Commission was correct to accept the referral of the transaction. What do you think about just looking at it from a practical point of view, in terms of doing deals, and in particular writing conditions precedent and kind of cooperation mechanisms in agreements on acquisitions. Have you seen that kind of thing coming up? And do you have any tips on how, practitioners can think about trying to protect and agree what the parties should do in these types of cases?
Well, yeah, absolutely. This new Article 22 approach has major implications on deals and on the M&A process. Specifically, the uncertainty that we discussed earlier relating to timing, but also to the feasibility of the deal, will need to be addressed in the transaction documents. So, as you say, conditions precedent in share purchase agreements or any other transaction documents will need to consider for the possibility that a transaction is referred to the European Commission, even by member states that do not have jurisdiction. Similarly, transaction documents will need to include an effort clause to anticipate intervention outcomes by potential regulators and also to ensure timely cooperation of both parties throughout the merger process. Finally, the long stop dates will need to accommodate a potential referral process, including the possibility to renegotiate the long stop date should a referral be made. As we have seen in the Illumina GRAIL case, a referral to the European Commission can substantially lengthen the review process at a minimum 3 to 4 months. So this is an important element that will have to be taken into account. And finally, just let me conclude that, as we have said earlier, parties will need to undertake an upfront substantive competition analysis in addition to the purely jurisdictional analysis to determine a potential antitrust risk, but also the possibility for a referral to the European Commission. Particularly in certain industries, so definitely tech and pharma, and certainly in cases of doubt, the Commission includes in its guidance the possibility for an informal approach to determine whether you're in front of a candidate for referral.
Yeah, that's all that's all good stuff, I think. Thanks, Salomé. Before we move on to the final segment with Christina, I just wanted to, just to say something that seems a bit ironic, really, but if you think about transactions that were looked at by the regulators and maybe they think should have been looked at differently, you can think of at least, Facebook WhatsApp acquisition, which was approved unconditionally by the EU in 2014, and also Facebook Instagram, which was approved unconditionally by the UK, then a member of the EU in 2012. So just leave a question out there, is the problem really that some of these cases were just not looked at properly as opposed to the jurisdiction not being there? But that's maybe a question we can discuss another time.
And Matthew, as many of our listeners know, both of those cases are being reviewed in the U.S., sort of a post-transaction review, and opens up a question as to whether post-consummation review is a better way of handling the transactions or pre-merger control. So it will be interesting to see how all of these cases develop, both in the EC and in the U.S. going forward. So, Salomé, thank you for this time. I think, as with any new rules, regulations, and in this case, guidance, there's a lot of uncertainty. So it's really helpful to hear your insights as to the ongoing developments and what practitioners should be thinking about going forward. Before we let you go, however, we just have a few additional questions for you. The first is if you have any advice that you have for young practitioners who are looking to do what you do.
Well, I usually give 2 pieces of advice. One, try to get some basic knowledge of economics if you didn't study it earlier. In my view, at the end of the day, it is really the combination of the best legal analysis with sound economic arguments that will allow you to win the case. And second, try try to define the kind of practice that you would like to concentrate on as early as possible in your career. Try to find those areas that really resonate with you, be it transactional, behavioral, or even both, because this will have implications in terms of the skill set development, but also on your lifestyle.
Makes sense. And Salomé, can you tell us something interesting about yourself that we wouldn't know about you if we only knew you professionally?
Well, from my professional CV, you probably cannot tell that I grew up in a small town by the sea in the Basque Country in Spain. Its hallmark is a bridge, and I was fascinated by this bridge. It is called Puente Colgante, the hanging bridge, and it was built by Alberto Palacio, a local architect and engineer who had studied in Paris with Gustave Eiffel. So the Puente Colgante somewhat resembles the Tour Eiffel, except that the iron structure is not something you climb up on to get a better view. It is used to suspend a gondola that floats in the air between the two banks of the river. I'm sure that many listeners will go to Bilbao at some point in time to visit the Guggenheim Art Museum. So if you do, I urge you to take the time to travel down the river to see this bridge. I'm sure it will inspire many ideas and dreams for you, just like it always does for me.
And finally, Salomé, the last segment, what we call the Curious Hat.
And now it's time for the Curious Hat!
So can you pick a number 1 through 10?
2.
2. When you were a young child, what did you want to be when you grew up?
Well, this might sound strange or even boring, but I always wanted to be a lawyer. Most men in my family were doctors or lawyers, and this clearly had an influence on me. But there was also my mother. She ran a small business, and I used to help her negotiate agreements or manage the suppliers. I guess that's really how I got interested in business law. I believe there is a reason why many professions run in families, and in that sense, I am no exception.
Well, that's great. A lawyer from a young age. So Salomé, thank you again for your time today. And to our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.